we are privileged today to have someone who is very close to Hiddush, but you have not heard, and that is Ambassador Alan Baker, a former ambassador of Israel to Canada, and more relevant possibly for the topic at hand, and a legal advisor of the Ministry of Foreign Affairs, and prior to that, senior officer in the International Law Division of the Judge Advocates in the Army. The session will be moderated by Judge Peter Buchsbaum, co-chair of JPLAN, the Jewish Pluralism Legal Action Network. Following the introductory notes that Alan will be providing us with, we'll have a short period of questions and answers, and you're most welcome to ask your questions or make your comments on the chat. And if there are questions that we won't be able to get to, we'll try to answer them in writing in a follow-up email on this webinar. The co-sponsors that Hiddush is privileged to have in offering these webinars are AAJLJ, the American Association of Jewish Lawyers and Jurists, JPLAN, as I said, the Jewish Pluralism Legal Action Network, and Ruach Hiddush, Rabbis and Cantors for Religious Freedom and Equality. So without further ado, Peter, the microphone is yours.
Okay, we are very fortunate to have Ambassador Baker with us. His resume, besides being Israeli ambassador to Canada, only begins there. He's been an advisor to the foreign ministry. He's been involved heavily in some of the UN discussions of the wars and the Israeli situation in the UN. So he's got an extraordinary background to present to us, and we're lucky to have him. I've got to say a local word. I see the president of my synagogue, Har Sinai of Pennington, has joined us. So Lisa, good to have you with us, because charity begins at the home. And with that, we're going to cover the basic outline is to ask Ambassador Baker to explain what the ICJ is, and then go through the definition of genocide, how it originated in the UN covenant after the Holocaust, what it implies legally, and then discuss the court proceedings. And that's, of course, Alan's free to deviate from that, but that's the essential outline we're going to follow. And then after the conclusion, as Uri said, we'll have the chat. So without further ado, I will turn it over to our most distinguished speaker, Ambassador Baker, to take it from here.
Well, thank you very much, Peter. It's good morning, good evening, good afternoon, wherever you are. I'll try and be as brief as possible so that you'll be able to ask questions, and I'll get the information that you need through answers to questions. But as you asked, first and foremost, what is this International Court of Justice? A lot of people mix up the International Court of Justice, which is a UN organ, with the International Criminal Court, which is an independent organization. The International Court of Justice in The Hague, as I said, it's one of the UN organs in the same way that the Security Council, General Assembly, Secretary General, Trusteeship Council, and all the various other parts of the UN. So is the International Court of Justice, call it the ICJ, which is the principal legal arm of the United Nations. It's for litigation between states. It's not for prosecution of individuals. Individuals can be prosecuted in the International Criminal Court, which is something else. We also have very serious problems with that court, but this isn't the subject of today's webinar. So the International Court of Justice, the ICJ in The Hague, is the principal legal arm of the UN, dealing with litigation between states that agree to grant the ICJ jurisdiction to litigate their cases, but also it has another function to provide advisory opinions on legal issues that are presented to it by the General Assembly or the Security Council or other UN bodies. That's the ICJ. Now, what is the Genocide Convention? And here it's somewhat ironic. The term genocide was coined by a Polish Jew called Raphael Lemkin in 1944, after all his family had been killed in the Holocaust, and he coined this term, which was immediately taken up by the UN as the name for the crime of destroying a whole people. And after what happened in the Holocaust, the international community came together and drafted the International Convention. It's called the Convention on the Prevention and Punishment of the Crime of Genocide. It was approved by the General Assembly in December 1948. It entered into force with the signature of, I think, 30 states on the 12th of January 1951. Now, what does this convention say? And it's a convention that virtually all the states of the world are party to. It basically defines genocide. And the definition, and I'll read it out to you. First of all, the contracting parties confirm that genocide, whether committed in peace or in war, is a crime under international law, which they undertake to prevent and to punish. What is the crime? In the present convention, genocide means, and here it's very important, any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such, meaning either killing members of the group, causing bodily harm or mental harm, or inflicting conditions of life calculated to bring about physical destruction, imposing measures to prevent births, and forcibly transferring children from the group to another group. This whole crime hangs on one particular element, the intent. There has to be an intent to commit genocide. If there's no intent to commit genocide, then it might well be something else. It might well be violations of the laws of armed conflict, but it's not the crime of genocide. And this is the basic issue before the ICJ at the moment, where Israel is responding to the South African accusation that Israel is carrying out genocide, and Israel is responding saying, we're acting in self-defense against terror. We've got absolutely no intention of destroying the Palestinian people. And everything that we're doing is in accordance with international law. Another question is, where does this come from? How come South Africa, of all countries of the world, why is South Africa pursuing this? Not many people really know, but apparently the answer is that the Iranians are financing South Africa to a very large extent, and this is the payback that South Africa is giving to Iran by initiating this claim. Now, in a very long, an 80-odd page document presenting this prosecution, they're claiming that since Israel's existence, since the beginning of Israel's existence, for 75, 76 years, everything Israel has done has been directed toward the aim of destroying the Palestinian people. They weren't able really to come up with a lot of solid evidence of this. Most of their complaint is merely accusations without much evidence. The only evidence that they're giving are a few statements by minor Israeli politicians who irresponsibly called for Gaza should be wiped off the map, or various similar things. And they're also quoting a couple of Israeli pop songs. That's the depth of the legal basis for their prosecution. And what they're claiming, as I said, over 75, 76 years, everything that Israel has done, everything that Israel has said is leading towards the general aim of destroying the Palestinian people generally, and over the last 3 months, destroying all the population of Gaza in particular. Now, the judges of the court is composed of 15 judges representing the major geographical groupings of the United Nations. The US, Russia, the US is the president of the court, Russia is the vice president, Slovakia, France, Morocco, Somalia, China, Uganda, India, Lebanon, Japan, Germany, Australia, and Brazil. And according to the rules of the court, when one state prosecutes another state, then both the prosecutor and the defending state have the right to appoint an ad hoc judge. And so Israel has appointed the former president, Chief Justice Aaron Barak, as its ad hoc judge, and the South Africans have appointed one of their senior lawyers as an ad hoc judge. So there are 17 judges, 2 of which are ad hoc. Now, the irony in this whole thing is not just the fact that the term genocide was intended to deal with what happened to the Jewish people, but the other element of the irony is in the fact that the charter of Hamas and the charter of the Palestine Liberation Organization both refer to a very clear intent to destroy Israel. And it's a genocidal intent, and it's formal, and it's above board, and it's open to the international community, and it doesn't leave room for any doubt. And they're frequently repeating that this is their ultimate intention. This is what they intend to do, that there's no room for any Jewish, and for that matter, Christian presence in the area of the Middle East. And their aim is to destroy this presence. So this is the second ironic element of this whole thing. So this is where we stand at the moment. On Thursday and Friday, the court held 2-day hearing. On Thursday, the South African delegation presented their case based on, as I said, the 85-page petition to the court. And on Friday, the Israeli legal team presented its defense, detailing all the various points that I've made out during the last 5 or 10 minutes. What is South Africa requesting from the court? First of all, they're requesting that the court declare the fact that Israel is carrying out a genocide. This usually takes 1 to 2 years for the court to examine evidence, if need be, hear witnesses. But in the meantime, according to the rules of court, the court can be asked to give an interim order to prevent any continuing act that involves carrying out the act of genocide. And what might well happen in the next couple of weeks, the court might well come up with an order, an interim order, calling upon, as requested by South Africa, calling on Israel to do something or not to do something. It's difficult to know what. It's highly unlikely that they'll call upon Israel to stop the fighting, because the fighting isn't part of an intention to commit genocide. The fighting, Israel's fighting, is part of its defending itself according to the rules of international law. So it's highly unlikely that the court will come down with some type of instruction to cease fighting. In my opinion, based on the previous such cases, a case between Russia and the Ukraine a couple of years ago, the court will probably take some type of typically UN medium line and call upon Israel to make every effort to prevent harming people and to enhance the possibility of humanitarian assistance. In my opinion, this is what will happen, because as I listed the states, members of the court, you'll see that it's a mixed bunch. There's no chance that the Moroccan or the Lebanese or the Russian or the Somalian will support Israel in any way. Perhaps the Chinese as well, and nobody knows about the Indian. But the Japanese, the Germans, the Australians, Brazil, Slovakia, France, and the US would certainly shy away from coming down with some type of instruction to Israel to cease any further armed conflict. The question is, okay, assuming that such an interim order or interim instructions are given by the court, what weight do these instructions have? Whilst the judgments of the court are considered to be binding on parties that have agreed by signing the Genocide Convention to accept the jurisdiction of the court, this type of interim order, it hasn't got mandatory force, which would mean that if Israel chose not to carry out whatever instruction is given, then there would be a possibility of going South Africa or whoever else going to the Security Council and asking for Security Council action. Now, Security Council action can be in two ways: making recommendations, which are non-binding, or, according to the 7th chapter of the UN Charter, determining binding mandatory measures such as sanctions, financial sanctions or economic sanctions, or sending an international force. And it's highly unlikely, again, that the United States or the United Kingdom, and possibly more, all who have a veto power, would go along with something as drastic as that. So it's open as to whether, first of all, the court will issue some type of interim order which would require a Security Council action, and it's also questionable whether the Security Council would take action which would be mandatory. So that's where we are at the moment. Everybody's waiting for the outcome of the initial discussions, and as to whether there'll be some type of interim order and what it will be. So now I'll be very happy to answer any queries or questions that you want to ask.
Well, I don't have anything in the chat quite yet, so I'm going to ask you something. What did Israel argue, and who presented its case?
Okay, the case was presented by a British barrister called Professor Malcolm Shaw. He's a colleague of mine. We studied international law together at the Hebrew University, a very prominent barrister who frequently appears before the International Court of Justice and is widely respected and widely known. He was accompanied by Dr. Tal Becker, who's the legal advisor, the present legal advisor of Israel's foreign ministry, and a representative of Israel's ministry, two representatives of the Ministry of Justice. I don't remember their names, but the head of the International Law Division and another member of the International Law Division. And they presented Israel's case, covering the fields that I've covered, and detailing in great detail why the court doesn't have jurisdiction to call for interim measures, and why the court doesn't have any jurisdiction even to deal with the accusation of genocide, because there's no intent, and therefore if there's no intent, the court can't deal with it.
If I can add to Peter's question, can you, if you detach yourself from your obvious stand, can you assess the quality of the South African pleaders and arguments, and why did they choose to petition regarding genocide rather than possibly other breaches of international law of armed forces?
Well, okay, look, anybody who reads a South African presentation would probably find it quite comical, as I did. It really is not serious. As an international lawyer, familiar with such pleadings, it really is not serious. And as I said, as far as I'm given to understand from various sources, this was something that was pushed by the Iranians who paid for it. Whether this will come out or not, I don't know. What was the second question?
The second question was, why was the strategy chosen to attack the genocide angle rather than some other breaches of international law of armed forces?
Look, the issue of breaches of international law, the laws of armed conflict, they are the subject of several, I would say more than several, probably hundreds of complaints by the Palestinians to the International Criminal Court, also in The Hague, not a UN body, aimed at specific people, whether it's Israeli politicians or Israeli military leaders, accusing them of giving orders that violate the laws of armed conflict. That court hasn't yet decided whether it has jurisdiction, because in principle, the Palestinians, not being a state, haven't got the standing to appear before the court, although the court has basically recognized the fact that they are a non-member observer state in the UN. So this court is presently dealing with complaints regarding violations of the laws of armed conflict, and I can only presume that after the last 3 months, there'll be a new batch of complaints by the Palestinians regarding various aspects of the fighting in Gaza. But Israel has been very careful to justify every action taken. And when one thinks, for instance, about, well, how come Israel destroyed a hospital or a school or private homes, then there's very detailed and documented answers showing that in that hospital or underneath that hospital, there was a major Hamas headquarters. There were storage rooms for Hamas missiles. And in fact, part of the Hamas's policy has been to hide behind human shields in the form of schools, mosques, hospitals, and private homes. And all this has been documented. And in accordance with the rules of armed conflict, as soon as a protected area or place or building or institution is used for military purposes, then it loses its right to protection and it becomes a legitimate military target. These aren't the issues that are being dealt with in the present issue regarding the Genocide Convention. And South Africa chose, for whatever reason, to base its complaint on the Genocide Convention.
Some very good questions have come in, and having been a judge and also a lawyer, this one, does the evidence matter here when it may be that the political inclinations of the judges, even before you get to the Security Council, will be controlling?
Well, this is the classical question, because when all said and done, the International Court of Justice, despite the fact that it's composed of senior lawyers, highly respected lawyers from each individual country, here there's no doubt about it, and each one of them swears an oath to act impartially. We're talking about a UN body, and the UN is the UN is the UN, and it's highly likely that each of these the countries who sent their judges to the court will also probably give them instructions as to what they want them to determine in considering this case. So to a certain extent, you're right. Because it's a UN body, there's not much likelihood that the outcome will be something based on considerations of pure justice. There'll also be political considerations.
Well, that's a shock. Next question, and there's a series here, challenges your statement that the only evidence was statements made by minor actors, and contains references, which I haven't had a chance to check, obviously, to statements made by the Prime Minister, the President, the Minister of Defense, and others. What's your reaction to that?
Well, the Prime Minister, the Minister of Defense, Chief of Staff haven't made any statements referring to or calling for any type of or indicating any intent to destroy in whole or in part the Hamas in Gaza or the Palestinian people generally. And the Prime Minister came out in response to these accusations by South Africa, saying very clearly that those people who made any such statements are minor politicians that don't determine what Israeli policy is. The Israeli government determines such policy and isn't influenced by individual politicians who, for their own political or other reasons, make irresponsible statements. But Israel being an open and free country, nobody can prevent people from saying what they want to say, as irresponsible as it might be.
And another series of questions are very interesting. Can the tables be turned? Can Hamas be charged with genocide against Israel? And then a further question from a classmate of mine in college and law school. Does that intent to commit genocide on the part of Hamas relevant as a defense on by Israel? So you have two sides of the coin here. Can Hamas be charged? And if so, or even if not, does its intent serve as a defense for Israel?
Look, Hamas isn't a state, so it's not party to the Genocide Convention, and therefore, even if Israel wanted to accuse Hamas of genocide, and there's sufficient proof and evidence to indicate that this is their basic intention, there's no way of doing that. In the International Criminal Court, however, there have been several complaints by various organizations, Israeli organizations and Jewish organizations, accusing the heads of Hamas and the leaders of Hamas of war crimes, violations of international humanitarian law, crimes against humanity, and I haven't seen, but I will presume also intention to commit genocide. That these are accusations against individuals, specific individuals, terrorists, senior terrorists. There's no way of actually bringing Hamas to this type of international court. The second question, remind me, what was the second question?
Is Hamas's activity and its genocidal intention potentially a valid defense to any charge of genocide being committed by the Israelis?
Well, you know, the issue isn't tit for tat. You know, it came out in a recent judgment by the International Court of Justice between Russia and Ukraine that because Russia claimed that the Ukrainians are carrying out a genocide against those two provinces in the Ukraine, I've forgotten their names, just because of that, that doesn't justify Russia's attack against the Ukraine. So the court basically has said that one thing doesn't justify the other. But you know, what action can be taken against? Can Israel use this as its defense? Well, as far as I know, Israel is using this as its defense, and when the court comes to dealing with the actual accusation and not the request for provisional measures, Israel, part of Israel's defense is, first of all, that Hamas in and of itself is a genocidal organization. It doesn't hide behind it, but also the fact that Israel has signed several agreements with the Palestinians, aiming to live in good neighborliness and peaceful relations, is indicative of the fact that Israel has never had any intention of carrying out a genocide. Otherwise, why would it have negotiated and signed these various agreements? And so it's basically illogical on the part of South Africa to ignore all these very important elements and just base themselves on statements by minor politicians to bolster their case.
Okay, then I mentioned that I haven't been mentioning the questioners, but in this case I will, just because I thought of it in time. Ellen Messer asks, and this is a really good question in particular, so much of human rights legal judicial process involves political responses to alleged violation. And we certainly experienced that here in the US with the civil rights movement, which is both a political movement and a judicial movement. So the question really is, what about the political context here? Is the political context likely to affect what some of these Israeli actors are saying and kind of produce some change in their rhetoric or nudge the rhetoric in a more positive direction? Or will the Israeli political scene just be unaffected by any political outcome?
Okay, anybody who's familiar with the Israeli political scene, and Ori will probably laugh, knows that it's a complete and utter catastrophe. And it's very
not funny, but I can't help but laughing.
Okay, probably very similar to other political scenes. I remember when I was ambassador in Canada and I used to appear in Parliament. You know, there was no less of a balagan there than there is in Israel's Knesset. So it's you know, that's internal politics. There's a very strict division between, or separation between, the internal Israeli politics, and people talk a lot of rubbish, but also speak a lot of sense, and international politics, which is only dealt with by those people whose job is to dabble in international politics, and they're fully responsible for what they're saying.
Well, to follow up, Benjamin Usha asks if there were an order to cease from the court, and presumably the Security Council is subject to a veto and doesn't directly enforce it. Should Israel nonetheless just completely ignore it, given the political context and potential political consequences of such an order?
Look, Israel is acting in accordance with its basic security interests, which involve two elements. One is returning the 165 hostages, and secondly, neutralizing Hamas's military capability. Until it achieves these ends, I don't think Israel will agree to stop carrying out its military actions, because if it stops carrying out these military actions, and if it doesn't succeed in bringing or getting the hostages freed, then the hundreds of Israeli soldiers who've been killed during this military action will have been killed in vain. And so there's a huge emotional but element of principle in the fact that Israel is obliged vis-a-vis its population and vis-a-vis the families of the people who are held hostage and the people who've been killed, to complete this action and not to do anything other than complete this action. And so I don't believe that Israel strategically or tactically will agree to halt any type of action. It might well change the type of military action, and this is indeed happening as we speak. The major brunt of the attacks, of the military attacks, is now changed, and it's becoming more individual raids by special forces. So the major element of the armed conflict has changed. But I don't see Israel agreeing to stop this until it achieves its aims. And I think that the United States and some of the European countries are still supporting Israel in this. It's difficult for them because of the huge amount of propaganda that's coming out, especially through millions and millions of dollars spent by Qatar and Iran to finance a lot of this propaganda, including these huge demonstrations, by the way, which are being financed. But the United States and other countries are still supportive of Israel, and I don't think this will change.
And that relates to a question from Ron Cohen. What evidence is there for the assertion that Iran has provided South Africa with financial support? Or,
as far as I know, it's very strong evidence. I can't read it out to you because I haven't got it with me. But apparently, South Africa, which, by the way, is in a very serious internal, has very serious internal problems and huge debts. All of a sudden, their debts disappeared after they instituted this prosecution.
Okay, and Kathy Horowitz, I'm going to take a couple more questions, and I'd ask you to sum up. And Uri has been unusually quiet, and I know he must have some things he wants to say. So we're about a quarter of. We'll try to wrap this up at 1 o'clock. Could Israel ask for alternative provisional measures, such as unconditional release of all the hostage, or disarming or surrendering of Hamas as a condition of any relief that's granted? Would that be within the province of the ICJ?
Well, I think this is part of Israel's pleadings on Friday. since the hostage issue is a central component of Israel's action, then clearly, if provisional measures are called for, then they're going to have to involve some type of provisional measure calling upon Hamas to stop firing missiles, which is still being fired every day. As far as I know today also, they're still firing missiles and they're still holding the hostages, and they're not allowing the Red Cross to visit the hostages, and they're violating all the basic norms of international humanitarian law every day with everything they're doing.
So you're suggesting that to some extent this procedure could be used as leverage?
Possibly.
By the Israelis.
Possibly. Remember there's an Israeli judge on the panel. And I think we expect that the Israeli judge, when they sit down and consult and prepare responses to the request for provisional measures, I would expect the Israeli judge and the American and the Slovakian and others to stress these points.
This is my question. How did Aaron Barak get appointed? He's the by this government, I would assume, because he was the architect of the so-called constitutional revolution, which empowered the courts to declare acts of the Knesset unconstitutional. So how did they come to pick him to sit on the court?
Well, Peter, there are some sensible things that Israel does. And, when it comes to a serious issue, then, the right person at the right time in the right place is only Aaron Barak. And whatever one might think of his judicial reforms in the past, he is one of Israel's most brilliant lawyers. He was involved in the negotiation of the peace treaty with Egypt. He was Attorney General, and he answers all the requirements of an ideal judge for this type of case, and therefore I'm certainly very happy at the fact that he has been appointed and he agreed to take it on. He's not a spring chicken. He must be around 90 years old.
87.
87. Okay.
He is a spring chicken.
But nobody has asked. I don't think anybody has asked the question: why did Israel agree to go and do this? And
why did Israel agree to go before the court?
Yeah, I ask this question all the time because the Russians have very easily brushed aside such requests and ignored them. But of course, Russia can afford to. Russia's got the size and the power. Israel has always had a very serious relationship with the International Court of Justice. One of Israel's greatest international lawyers, the late Shabtai Rosen, he was given the Israel Prize for his doctoral thesis on the International Court of Justice. And to this day, the judges of the court rely on it's called the Bible, on his book, analyzing every article of the statute of the Court of Justice. And so Israel has always taken this very seriously, despite the fact that in the early 60s or late 60s, Israel declined to agree or cancel its agreement to the general jurisdiction of the court to deal with issues concerning Israel's very right to exist. But it still has agreed to, as part of the Genocide Convention, to grant the court jurisdiction to deal with complaints against Israel or Israeli complaints against anybody else. But I think the real reason for Israel deciding to go ahead with this, because by the way, when the issue of the an advisory opinion was requested in 2004, as to the legality of Israel's security fence, I was then heading the team dealing with this. The government decided not to cooperate and not to send a delegation because it would be tantamount to giving credence to the actual complaint. As it turned out, of course, the advisory opinion that came out was basically very flawed, but by a majority said, well, Israel has to remove its security fence, despite the fact that the security fence has saved thousands and thousands of lives. But of course, Israel ignored it. Here, Israel considered this to be a huge stage for Israel to explain its case, for Israel to explain, to justify why it entered into this war, to remind the international community of what happened on the 7th of October. And this was done by Tal Becker, the legal advisor of the Foreign Ministry, in his presentation. And then I would certainly recommend seeing his presentation. It's just a few minutes, but it's a very powerful presentation, which is a major part of which is the issue of the hostages. Israel decided that because it can justify every act that it's taking in this war, then it should present this to the world, and there's no better stage to do that than the International Court of Justice. Even if the court is composed of a majority of states or representatives of states that either don't have relations with Israel or are hostile to Israel or would receive instructions in any event to vote against.
Thank you. There was a question about the ICJ's ability to enforce any decision, but I think you covered that in your remarks about the Security Council. But the final question, which is maybe a bit parochial, but logical, Merle Halbrecht of Ottawa asked, you are a former Canadian. What about Canada's views on these issues? Does Canada support Israel's position? And I see Mark on Sean, other Canadians on the call, so it'd be good to hear what you have to say about that.
Well, I must say that I personally was quite disappointed with some of the statements made by the Prime Minister of Canada, basically joining the international choir of those calling upon Israel to stop actions that bring about deaths of Palestinians, and to enable the more humanitarian assistance to come in. I would have expected from Canada more support, similar to the type of support that Israel has received from Australia and from Britain and from the United States. And that hasn't been forthcoming, to the best of my knowledge.
Okay. Are there any concluding comments you'd like to make before I turn it back to Uri?
Peter, well, before the concluding remarks, there was one question which I think is worth raising because it points to a different angle than we have been addressing so far. Jen Kaufman is asking, do you think the attempts of judicial reform had any impact on these charges being brought? What impact will judicial reform in Israel have on holding Israel before the ICJ or even the ICC? Now, I don't know that this is a matter of concern, but I think there is an angle that is not fully understood by many who are reading about the situation, namely, to what extent is the International Court sort of withdrawing from adjudicating petitions against Israel because of the internal judicial system in Israel. Namely, to what extent is a strong, independent, highly regarded judicial system a defense mechanism for Israel and other countries when addressing international charges? And connected with that to some extent, can you help us in suggesting if the issue was not the covenant, the genocide covenant, but rather the questions involving armed conflicts, where is the line drawn between legitimate defense and taking measures that involve a large-scale harm to civil population?
Okay, well, I hope I won't forget the second question. First of all, I'll answer the first question. Look, the importance of an independent, highly regarded Supreme Court in Israel or legal system in Israel is vital with regard to the International Criminal Court. Because according to the statute of the International Criminal Court, which I was involved in the negotiation and drafting of the Rome Statute, if the state whose citizen is being accused of war crimes has such a highly respected and independent legal system, then the court doesn't have jurisdiction to put on trial people who are accused. As long as Israel maintains its independent judicial system, then the International Criminal Court can't take action against Israeli senior politicians or military commanders, because the Israeli court system, including the military court system, has the capability and the independence of being able to deal with this. I don't think this is relevant with respect to the International Court of Justice. Israel's legal system has always been the pride of Israel and its independent legal system and its Supreme Court, and it's always been a model for copying by other countries. And I learned this in Canada when a lot of the Canadian Supreme Court judges hosted Israel's Supreme Court and said such that you know they learned a lot from Israel's experience. What was the second question?
Second question was with regard to the rules governing armed conflicts.
Yeah.
Is there a red line? What is the line between legitimate defense in instances where the acts of defense involve mass damage and harm caused and casualties to civil population?
According to the rules of armed conflict, if the military advantage outweighs the civilian, the danger of harming civilians, then the military advantage is the higher consideration. But it's always something that commanders in the field have to take into consideration. And when Israel had to take action against the central hospital in the Gaza Strip, they managed to neutralize the Hamas headquarters under the hospital without harming any of the people who were being treated medically in the hospital. And this is the type of judgment that Israel's military has to make. And both of us were part of the Military Advocate General's unit in the army, and I was also involved in the International Law Division, and in the most recent conflicts, the International Law Division has its military lawyers at all the army headquarters advising the commanders before any action is taken and considering whether the military advantage outweighs other considerations. So what Israel is trying to do is to strictly maintain the norms of armed conflict and the humanitarian norms, but at the same time not prejudice or compromise its capabilities of neutralizing the Hamas capabilities. And there's a considerable amount of criticism in Israel, in the Knesset, that the army is taking so much care to observe these international humanitarian norms that it's causing harm to soldiers in several cases. And this is always a judgment that the Israeli commanders have to take. I've lost you.
I don't know what the...
Oh, okay.
Yeah. All right.
That's an incredible task for commanders to make amidst the fog of war. I could imagine a judge taking 3 months to decide an individual situation like that, let alone having decide that briefly.
Sure. Look, there's
in the midst of a conflict. My other brief comment, Alan, is I think the case for judicial review in Israel for Barak is actually stronger than the case John Marshall made in 1803 for judicial review in the U.S. That's just my humble opinion. And with that, I'll, if you have a few concluding words, then we can turn it back to Uri.
Okay. No, with respect to the last point, there's a British colonel who was a commander in the fighting in Iraq on behalf of the British forces, Colonel Richard Kemp, and he's written extensively on Israel's military activities, and he says that military forces of the world can only learn from the way that the Israeli Defense Forces observes the norms and rules of humanitarian law, whilst at the same time carrying out the most serious acts of armed conflict. And I would certainly recommend to everybody in this Zoom to look up the various writings of Richard Kemp, because it's very important from the military point of view.
Well, first of all, before I turn it back to Uri, I just want to thank you, Ambassador, and to thank the questioners as well. This has been an extraordinary hour, and I think we've all learned so much, and hopefully we'll continue to learn. And it's been a pleasure to have you join us. And with that, I'd like to turn it back to our host, Uri, and give us good wishes for the rest of the day, and tell us where we should go next.
Thank you, Peter, and thank you so much, Alan. I think you have enlightened us on a rather complex situation that I'm sure many throughout the world and the Jewish community have been attempting to follow, but at times found it difficult to grasp the fine points. So thank you for making it far more clear than we have been able to do by reading the media. And I mentioned before that we feel very close to Alan, and that is because Alan Baker is the chair of our Israeli Hiddush non-profit organization, and we are always grateful to him and privileged to have him. And in the last reminder to those who registered, we included a link to the op-ed that he published in the Jerusalem Post about the court and the proceedings. We will repeat that link in a follow-up email that we'll send you in a few days with a recording of this webinar. And as I mentioned before you came on, Alan, and maybe some others in our audience today, Ian Morris came on a few minutes earlier, and we had a brief exchange, and he shared with us how the South African Jewish community feels and is torn and the challenges that the Board of Deputies is facing. And maybe we should hold a session in which we'll invite some individuals from the South African Jewish communal leadership to share with us the feelings and some of the things on the ground that are happening as a result of the decision of South Africa to submit this petition against Israel. And the reminder, February 12th, next month, Professor Susie Novot of the Israel Democracy Institute, Vice President, will be speaking with us about the recent landmark decisions of the Supreme Court, which are truly encouraging, truly strengthen our resolve to safeguard the independence and the authority of the Supreme Court from its detractors, who may have postponed their plans to unsettle the court, but have certainly not given up on them. So make a note in your calendars, February 12th at the same time. So thank you all. Thank you, Alan. Thank you, Peter. Thank you all who have joined us, and our co-sponsors, the AAJLJ, and JPLAN, the Jewish Pluralism Legal Action Network, and Ruach Hiddush, Rabbis and Cantors for Religious Freedom and Equality in Israel. Shalom, Laila Tov, Yom Tov, Toda Rabba to all.
Toda Rabba.